Join the only roundtable podcast in compliance with 5 of the top commentators in compliance. Mike Volkov brings 35 years of legal experience. Matt Kelly is the founder and editor of Radical Compliance. Jay Rosen is Mr. Monitor who knows his way around the culture of compliance. And Jonathan Armstrong, a partner at Cordery Compliance in London, rounds out this top group of compliance practitioners. Check out the rants and shout out at the end of each episode. Hosted by Tom Fox, the voice of compliance. Everything Compliance is a production of the Compliance Podcast Network.
In this episode of Everything Compliance, we have the full quintet to look at issues under the incoming Biden administration. Jonathan Armstrong asks if a privacy shield fix would be upcoming under Biden. Mike Volkov looks at antitrust enforcement going forward. Matt Kelly considers the SEC and other regulatory agency changes. Jay Rosen asks whether compliance programs and monitors under the Biden administration. And Jonathan Marks talks about the increased importance in data and data analytics. Shout-outs and rants follow the original commentary. I know you'll enjoy this episode. Everything Compliance is a production of the Compliance Podcast Network and a proud member of C-Suite Radio. Thanks so much for listening. If you have listened to this podcast before November 26th, I hope you have a very happy Thanksgiving. And if you listened after, I hope you had a happy Thanksgiving. Jonathan Armstrong, what have you been thinking about in relation to a upcoming Biden administration?
Well, I think the main thing probably on my agenda will be data transfer. And that's been I guess a problematical issue for many years now between the EU and the US. And for those of you who haven't followed the issue, this is the long-running saga of Max Schrems, who started with complaints against Facebook back in the day. That led to Safe Harbor being struck down, the scheme that many multinational businesses used to transfer data from the EU to the US. And that was then replaced by a scheme called Privacy Shield or Privacy Shield. And that was struck down this summer by the European Court. And there are many in Europe that seem to think that Biden will be able to meet some of the objections that the European Court had to data transfer in the Privacy Shield litigation, and everything will be rosy in the garden from now on. I hate to spoil that party, but I think that's naive. And for background, of course, the Safe Harbor scheme was struck down before Trump assumed office. And the main objection to any data transfer to the US, whether that be under Privacy Shield or whether that be under standard contractual clauses, the other mechanism of legitimizing data transfer that's common amongst multinational businesses, is the perceived overreaching of the U.S. security services and the fact that it is perceived that the U.S. government can spy on EU citizens in this case without EU citizens having any right of complaint. Now, at the end of the Obama administration, Safe Harbor was struck down, and President Obama, by executive order, put some measures in place. And it is right to say that the Trump administration were in part at fault for some of the deficiencies of Privacy Shield. For example, there was an ombudsman scheme, and Trump failed to appoint an ombudsman until quite late in the day, and we had an odd interregnum where somebody who I think's primary focus was on whaling was running the privacy show as well. So in some respects, there is some fault there with the Trump administration, but it seems to me that there's no proposed change that I've seen to U.S. national security laws, for example. And I don't think we can expect them to get any more generous. And that seems to be at least the weight of a lot of the political objections. If you listen to European parliamentarians, for example, a lot of them are talking about this perceived overreach. In some respects, I have some sympathy with US corporations. There's a recent report from the UN Special Rapporteur on Data Protection, Professor Joe Canatari, who said there is no gold standard of oversight of surveillance. And in many cases, the US are at least more open about their covert surveillance. If you contrast that with, let's say, regimes in China and in Russia, then it's hard to criticize the US. And where we might get a slight bettering of relations, I think, is whilst security is often the reason given, I think the other reason, if we're being really honest and open, is the perception that data is something that's wrapped up in trade discussions and in trade treaties. And I suspect that it was perceived that the Trump administration, let's just say, was less than constant in its trade policy and was perhaps less than rational at time, banning different products for different reasons and reacting to perceived bans of Harley Davidson by Twitter, etc., etc. So if trade policy is more consistent, then some of the other objections to trade in terms of data with the US will be withdrawn. So a bit of a long-winded answer, Tom, but I think the data transfer situation could improve marginally if the Biden administration is more consistent. But regrettably, I think compliance officers are still in for a really big piece of work in terms of data transfer and privacy, unless and until the Biden administration brings in universal privacy law on a federal basis against the US, which I hear isn't likely to happen anytime soon, and unless and until Biden restricts the activity of the security services in the US, which again I don't see happening anytime soon either.
Jonathan, do you see any ways for the Europeans to move from their position, or are we really at just a fundamental loggerheads on how we think about data in the U.S. and the EU?
I think the difficulty is, you see, that, and I know a number of people unwisely have criticized the European Court for not giving guidance, but that isn't the role of the courts. The role of the courts is to say, after something's happened, was it right or wrong? And they've said it's wrong. Schrems, I interviewed Schrems after the collapse of Safe Harbor and the proposed replacement with Privacy Shield and said to him, did he think the Privacy Shield would have any better chance in the European Court than the Safe Harbor? And he said, no, it's Safe Harbor with flowers on it. And I think we're back to this debate we've maybe had before of name a movie where the sequel is better than the original. The only two credible cases that I've heard are Paddington 2 and I think The Godfather. But I think it would be unusual if the sort of the third one in the series, whatever it's going to be called, Safe Harbor 3, The Return of the Treaty, was better than the original. I don't think it would have more chance in front of the European Court. So even if you get parliamentarians in Europe looking more favorably at a Biden administration, and by the way, I think they will, they don't have the power to control the court.
So that is an interesting level of intersection and sophistication, but let me see if I can even make it more interesting. We have a date of December 31st for Brexit. So how will the United Kingdom, you think, deal with this, with the permutations of not a Trump administration, but a Biden administration who may be less than forthcoming to the current Bojo administration?
I think in data transfer terms, the main issue for the UK is not UK to US. The main issue for the UK is UK to EU. So I think in some respects, the criticisms that the EU have of the US, some in the European Parliament also have of the UK. It is perceived that the UK security services have overreached themselves in the past, and there is an allegation that the UK security services compromised a Belgium telecoms network which was used by many MEPs, and that, I think, let's just say, upset them. So, but again, I think I get back to exactly the same as I said for the US. There's no golden standard of oversight of surveillance. The UK has an independent assessor who looks at the work of the security services. And as I've said, in some respects, in the UK, our covert surveillance is overt in that at least we admit it's happening. Versus other European jurisdictions, I think Professor Kanatachi said that he thought that at least 9 EU countries had covert surveillance that they didn't even admit existed. So I think UK to US, I don't see any particular problems. I don't know what the relationship is going to be like between Biden and Johnson. I mean, without being political, it depends on whether Biden can tolerate crazy airheaded buffoons or not. But I think the data thing isn't going to be the main source of contention between the UK and the US. I do think it's problematical for a post-Brexit UK in its relationships with the EU.
Matt Kelly, what has been on your mind around the incoming Biden administration?
Well, I have a lot of thoughts on that, although I also just wanted to follow up with Jonathan Armstrong's points, which are very well taken, although Star Trek II, The Wrath of Khan, was way better than the first Star Trek film, which was terrible. And so, therefore, that should also be right up there with Paddington and Paddington 2 and The Godfather Part 2. So the Securities and Exchange Commission under a Biden administration, I have been giving that quite a bit of thought. Now, the bottom line is, of course, that we don't really know much about SEC policy and enforcement to come, and we won't until we have an actual SEC chairman nominated, and we don't know who that person is yet. If we want to throw out some names, and we're all about rumors here at Everything Compliance, so I will. So far, I have heard Preet Bharara, who is the former U.S. attorney for the Southern District of New York in the Obama administration, and very well respected and very well known, especially these days. He has a miniature podcast empire. Stay tuned with Preet, which is well worth people's time. But, if Biden nominated Preet Bharara, and assuming he gets confirmed, that would be a very enforcement-prone sort of commission. On the other hand, we've also heard the name Gary Gensler. He ran the Commodities Futures and Trading Commission in the Obama administration. And Gensler is running the transition team for Joe Biden on all of these financial regulatory agencies, including the Securities and Exchange Commission. It would not be unusual for a transition leader to wind up running one of the agencies that person is reviewing. So we could see Gensler running the SEC, and that, I think, would be more of a policy-driven SEC, because Gensler implemented a ton of Dodd-Frank rules when he was running the CFTC from, I think, 2009 to 2014. He went into the second term of the Obama administration. My personal favorite, my sleeper candidate, I'm going to drop this name for everybody, Robert Jackson, who is a law professor at New York University, and he was a Democratic commissioner at the commission during the first part of the Trump administration. I love Jackson because he would drop these very data-driven studies that I am sure drove the SEC staff and current Chairman Jay Clayton up the wall because he would skewer with data all of these conservative policies that the SEC was trying to enforce. Did they ignore Jackson's data and force them through anyways? Yes, that is kind of the MO of the Republican Party these days. But I would love to see Robert Jackson come back as chairman. I think he would be excellent. But we don't know. We won't know for weeks at best, or at least possibly even several months. It is worth noting that Chairman Jay Clayton has already announced he's leaving at the end of this year. What happens after that? Probably for a tiny bit in January. Hester Pierce, who is a Republican commissioner, will be acting chairman. And then Joe Biden is sworn in on January 20th, which, yes, is actually going to happen, everybody, no matter what certain people in the White House like to pretend right now. But then once Biden comes in, I think that it would flip to Allison Lee, who is the Democratic chairman, Democratic commissioner, who's like the most senior of the two Democratic commissioners. She'd be acting chairman until they get their new chairman, and he makes the fifth, he or she. And then we're on to whatever comes next. So what actually does come next, and how do compliance officers have to think about it and care about it? I suspect we're still going to see a rather expansive view of SEC enforcement power. For example, we're going to continue to see the SEC enforcing the civil side of the FCPA, even when the Justice Department doesn't bring a criminal case on the same set of facts or misconduct. We've seen that happen over the 4 years of the Trump administration. I don't think that's going to go away, unless the only way that would go away is if the Justice Department starts bringing more criminal cases. But I don't think that we are going to see anybody say no civil enforcement because DOJ didn't bring criminal enforcement. We haven't seen it now. We are not going to see that happen in the Democratic administration. We saw another really interesting thing that just happened that I think is a good example of what I mean for expansive enforcement, is the SEC took the internal control provisions of the FCPA and applied it to insider stock sales at an energy company down in Texas called Endeavor. Fined Endeavor, which is now part of Marathon Petroleum, but fined Endeavor $20 million for poor internal controls over reviewing Rule 10b5-1 plans. And those are the plans that insiders are supposed to have to set a predetermined schedule of selling your shares if you're a corporate insider, so that you can avoid any sort of insider trading liability. And now we took the internal controls provision of the FCPA and applied it to insider stock sales. This is interesting because I personally don't recall seeing that before. The two Republican commissioners who are on the SEC right now actually published their own statement about why they dissented from that, which is unusual. But they basically pointed out that the internal control provisions are about corporate accounting, and an insider selling shares that he or she owns, like, that's not corporate accounting. That's some dude selling shares. And there are rules about it, but it's not corporate accounting. So what are we doing? And, the commissioners, including Commissioner Pierce and Elad Roisman, they're not wrong to say that. But then we actually had Chairman Clayton return fire. He gave a speech this week, just yesterday before we're recording now, where he explained that, oh, no, internal controls should apply to insider stock sales. And I'm sure the Democrats like that. They voted for that penalty anyways. So again, we see this expansive view of how you could bring a civil enforcement action. And I think the internal control provisions of the FCPA are a big vehicle for that. They're a very versatile sort of club you could use if you are an ambitious SEC prosecutor. And I think we're going to keep seeing that kind of stuff. My questions are, will Democratic leadership of the SEC try to expand specifically? Will they try to expand diversity and climate change disclosures companies need to make? Because that is something that the current SEC just passed some new rules, kind of mealy-mouthed about it. Yeah, you should disclose that, but figure out your own framework about what's important to say to investors and via con Dios. That was the Republican version of this rule. I wonder if Democrats might revisit this, come up with a much more prescriptive sort of rule about disclosure on diversity and climate change. Those are both subjects the Biden administration would like to tackle. They are both subjects that Democrats in the House would also like to tackle, that they can't tackle until they actually get the Senate, which I don't think they're going to do. So if you are Joe Biden, you could serve your own interests and keep your left flank in Congress happy by revisiting these rules. It might take a while to get that forced through, but you could do it. So it's those kind of things that I think we're going to see. More disclosure around corporate social justice issues or climate change or other ESG issues, maybe even something as far-reaching as a specific ESG disclosure framework that companies would need to use in the same way that most typically use the COSO framework for disclosures about your internal controls over financial reporting. Might the SEC point to an actual ESG framework to say this is what you should use for ESG disclosures? I suspect that will come. I suspect it will take some time. I suspect somebody somewhere will then challenge it in court once it actually happens, because this is what we do with the SEC these days. But compliance officers should be thinking, okay, how would we make that work? How would we find a good framework that might be defensible for the SEC? And various other things like that. But a whole lot of what the SEC has already been doing to tie you into knots, I think that's not going to go away. I have two other questions that I am curious to see what Congress and the SEC do here. Number one, will Congress enact a fix to the digital realty trust decision from the Supreme Court back in 2018? That was the ruling that said if you want, as a whistleblower, to claim anti-retaliation protections under the Dodd-Frank Act, you must report to the SEC. You cannot claim them if you only report to compliance officers. That is a bad ruling. The Supreme Court didn't even like it, but they said the law is the law. We're stuck doing it. So I suspect Congress might try and fix that. It is something that both parties in Congress have talked about fixing. I think they want to do it, except the lead proponent of that is Chuck Grassley, who is the Republican in Iowa, who is 87 and has just been diagnosed with COVID. I wish him well. I hope he endures and returns. But you're 87, you have COVID. This is an open question right now. We'll have to see if the people involved in pushing this are still going to be able to continue to push it next year. My other big one, and Tom and any other legal theorists, I'd be curious what you guys think. Will Congress try to fix the Kokesh decision from the Supreme Court in 2017, where the Supreme Court said slapped on the statute of limitations for SEC disgorgement as a penalty, and I think it's 5 years. And there's some talk in Congress about trying to do away with the Kokesh decision, which would give the SEC its unfettered power to impose more disgorgement as a penalty and go back to the way it was before the Kokesh ruling. So there's a couple of things that might happen in Congress. I think there's interesting things in the SEC. And above all, who is going to be the chairman? I don't know. And we can talk about it in months to come. But that's what I have on my radar screen.
Jonathan Armstrong, you have a question for Matt?
Yeah, Matt, you talked a little bit about environmental enforcement. And of course, in one of those strange coincidences, the US's notice to pull out of the Paris climate agreement expired the day after the election. So the US has been the first country to withdraw from those climate change rules. Is this connected? Do you think the US will jump back into the Paris climate agreement, and will that mean that there is more enforcement of environmental rules, tougher emissions enforcement, all of that sort of stuff?
Yes. Joe Biden has already said that the moment he is president, he is going to bring the U.S. back into the Paris Climate Accord, which officially we did not withdraw from until like just the other week. Even though President Trump announced that quite some time ago, there was a long withdrawal period, which only just now came to fruition. So we have this little interregnum right now where we are out of the Paris Accords. We're going to be back in them on January 20th by that afternoon. As to what happens with environmental enforcement, it'd be very interesting to see who will run the EPA. and what sort of rules they will try to put forth and what sort of enforcement they'll try to do. The SEC can really only regulate what disclosures companies make about climate risks to investors, but they can still do a lot there. That could still leave a lot of EHS and compliance officers and corporate secretaries pulling your hair out, trying to figure out what's the right thing to put in our 10Qs or the 10Ks. So I think we'll see a lot of action there. I don't know what it is. That is a subject where I think Republicans will go tooth and nail, kicking and screaming, opposing anything on tougher climate change or environmental regulation, because they are just generally anti-environment on their policies. They have been for the last 4 years. It'll be curious to see, but that is where things seem to be going right now.
I have a question for you about the PCAOB. Early in the Trump administration, and indeed Commissioner Jay Clayton's tenureship at the SEC, there was a lot of turmoil at the PCAOB. I believe all 5 members of the board had to resign or did resign. Do you see anything coming out of the Biden administration around the PCAOB?
Oh, that's a good question. I haven't quite thought about it. They will start to have PCAOB members rotating off or coming up for reappointment. All 5 PCAOB board members were ousted at the beginning of 2019 after a major scandal there. So we have 5 new members, and slowly but surely their terms are going to start to expire. We don't necessarily know how the PCAOB will change. The only thing we do know right now is the PCAOB is not going to go away. There has been talk, and once upon a time, way back when, people forget this, the original proposal for the Sarbanes-Oxley Act was that the PCAOB would be a division within the Securities and Exchange Commission. You'd have division of enforcement, division of corporation finance, you'd have a division of public auditing. And that never happened. They established an independent agency. Big radical change like that is going to require legislation. I don't think Congress is going to be able to legislate anything along those lines anytime soon. So we're going to just have the PCAOB slowly but surely bend towards more traditional democratic approaches to policy and enforcement, but that's going to take time.
So, Mr. Rosen,
yes, sir.
What have you been thinking about, rather, on the incoming Biden administration?
Well, I've been thinking about what the Biden administration will mean for corporate monitorship. So just to give everybody a little background as to where that comes from and where the thinking may be going, the criminal division's fraud section reported a record-breaking penalties for this year in corporate settlements resolving egregious conduct. Yet none of the penalized companies were assigned an independent compliance monitor by the Department of Justice. Monitorships can be an effective tool for remediating corporate misconduct and preventing recidivism. Agreeing to a monitorship can also be a helpful way for a company to close a corporate plea negotiation and to avoid more onerous alternative terms. However, once in operation, monitorships also present the potential to be exorbitantly expensive and unnecessarily intrusive on a company's business operations. DOJ guidelines recognizes the need to strike the right balance because neither the company nor the public benefit from monitorships whose scopes are overboard. The guidance specifically reminds prosecutors to be mindful of the cost of a monitor and its impact on the operations of a corporation. The most recent DOJ guidelines suggest that monitors should be used sparingly and only in the most egregious circumstances. Specifically, the 2018 Benchkowski memo states that the DOJ should consider imposing a monitor only when there is a demonstrated need for and clear benefit to be derived from a monitorship relative to projected costs and burdens the monitorship will impose on the company. It is noteworthy, however, that almost half of the criminal fraud section corporate FCPA resolutions since Benchkowski involve corporate monitors. In 2020, the fraud section has agreed to 7 foreign bribery corporate resolutions, including with European aircraft manufacturer Airbus and investment bank Goldman Sachs only a few weeks ago. Earlier this year, Airbus agreed to pay nearly $4 billion in a settlement for bribery and U.S. sanction violations, with the majority of the penalty going to French and British authorities. Goldman Sachs also entered into a large settlement with the DOJ in October, agreeing to pay nearly $3 billion to resolve its roles in the bribery embezzlement scheme concerning Malaysia's development fund, 1MDB. In some of these cases, the DOJ determined that imposing a compliance monitor was unnecessary because the company had fully remediated and upgraded its compliance program by the time of resolution, while in other cases, the agency deferred to a foreign authority's monitorship regime. Here are some potential factors why. Companies are remediating earlier. Over the last few years, companies have become better at remediating and fixing their compliance program early in the investigation process. This reduces the chances of the need for a monitor. Companies are starting to understand the need to start their remediation efforts earlier in the course of an investigation so that by the time they are discussing a resolution, the company is much further along in the advancements of its compliance program than they had previously been. Corporations can also thank the Benczkowski memo introduced in late 2018 by the former criminal division chief Brian Benczkowski. The memo unveils a set of factors, including the cost and potential benefits that prosecutors should take into consideration when deciding whether to impose a monitorship. The guidance states that the imposition of a monitor will not be necessary in many corporate criminal resolutions, and that the scope of the monitorship should be, quote, tailored to address the specific issues, unquote, and the needs of the company. One consistent theme is that the state of the existing compliance program and remediation are the two most important factors for the government to consider when determining whether to impose a monitor or not. And we have seen in recent cases that companies have presented enhancements to their programs and evidence of remediation to persuade the government that a monitor is unnecessary. The Benczkowski memo is a progression of the two other DOJ monitorship memorandums, including the Morford guidance issued in 2008. The Morford memo was created in response to a controversial decision made by then New Jersey U.S. Attorney Chris Christie to award a lucrative monitorship to former Attorney General John Ashcroft. The incident raised concerns that with a lack of clear guidelines, there would be little oversight over the selection of monitors. The memo was left broad and open for interpretation, hence the subsequent guidance, including the Brewer and Benczkowski memos in 2012 and 2018, respectively. They gave clearer guidelines to prosecutors. Since those memos, the frequency of monitorships has declined. A recent OECD report found that companies settling FCPA violations were twice as likely to receive a monitorship between 1998 and 2010 than in the 10 years since. The current administration's reluctance to routinely impose a monitor is another subtle but significant reason for the continued drop in monitorships. As the Benczkowski memo outlines, monitors should be used sparingly and only when it has been determined that there would be a benefit for the company. Lawyers said that in previous administrations, there was some criticism that the monitorships were being imposed frequently and weren't geared towards the specific needs of the company. This criticism was that monitors were being used too often and that the scope of monitorships were too broad. The purported intent behind the Benczkowski memo was to take a more tailored approach to monitorships and address the current needs of the company. The egregious conduct uncovered during the investigation shouldn't justify our monitorship, and the focus should be on whether the company has fixed and upgraded its compliance program. Monitorships are supposed to be aimed at answering the question, how do we get this company back on track, and only relevant to the underlying conduct if it hasn't been remediated. Under a Biden administration, we can anticipate an uptake in regulations which include corporate enforcement. As you have more corporate cases, the opportunities to impose a monitor may increase as well. The government's policy really should be to encourage companies to fix their compliance program themselves, and that's a huge incentive to avoid a monitor. One thing that sometimes gets lost in this discussion is it's not about having a monitor, but more importantly, it's about having an independent corporate monitor. Sure, a company can self-scout and analyze where they have gone wrong in the past and take a look at their current E&C efforts to see where they fall short. But by having an independent corporate monitor, this extra level of outside scrutiny allows a monitor to be dispassionate about the company that they're working with and helping to remediate ethics and compliance shortcomings and shore up their program for future success. So I guess the bottom line, guys, is that I look forward to seeing an increase in regulation of FCPA matters, and that when necessary, I think the Biden administration will look to introduce independent monitors.
Mike Volkov, do you have a question for Jay?
Yeah, Jay, I take your comments, and I guess here's a question. I even think within the last 4 years, DOJ has been sort of inconsistent in their monitors in FCPA cases. For example, in 2019, they imposed monitors in the MTS Russia cellular case for Xenius, and I think it was Ericsson. They didn't impose one in Walmart. And then we had this year Goldman Sachs, which to me is the most inexplicable case for not imposing a monitor, when you had particularly the senior management recordings that they had indicating the sort of absence of any tone at the top, if anything, senior level misconduct at Goldman Sachs that far exceeded, the bad actors. How do you even... I mean, it seems like the last 4 years have been, like the president sort of veering one way, then veering another, but it seems to me like wildly inconsistent. Can you see any consistent theme in the way they've been applying this issue? I mean, and it's all been under Benczkowski's watch.
Yeah, I think you bring up some real good points here, Mike. I would agree that there is inconsistent application, but I think the one thing that DOJ should be commended about, and I think we all speak about this frequently, is that the amount of guidance that they have given to the marketplace has been laudatory. That to have not only the Benczkowski memos, but other looks at how the other regulators are working with this information. I can agree with the fact that maybe there has been a decrease in monitors because companies are doing a better job of self-remediating, and they know where the guardrails are and they know what they should do. But I do believe that the next step going forward would be to bring some consistency because, as I said in my remarks earlier, you really can get something more by having an independent monitor. And by defaulting to, you're going to let a company, do its own remediation, but the company on its own got into a bad place. So why would it make sense to allow them to self-approve themselves and self-remediate?
Yeah. Just a bit of news. I actually had a chance for a client conference for a vendor to interview for a week David Last for the current head of the FCPA unit, and got to get into a lot of issues with him. And in particular, I think the headline that came out of that is, hold on for compliance requirements and hold on for expectations. These guys, the department, at least as he indicated, are really up on compliance issues right now. And I think we may see sort of another, if the Biden administration is supportive, we may see another big sort of push in expectations surrounding anti-corruption compliance and programs.
Jonathan Armstrong, do you have a question for Jay?
Yeah, I do. And just before I move on to that, to Mike's point, I'm hearing the same mood music from the UK as well, that it may well be that the SFO is also going to have a push on compliance programs, particularly in connection with DPAs. And that leads me to my next question. The Rolls-Royce Deferred Prosecution Agreement was signed in, I think, the last days of the Obama administration. I guess to quote the words of the great Kylie Minogue, on the better the devil you know principle. Do we think the hive mind, and Jay, do we think that we're going to see a similar rush to sign up DPAs as we come out of the Trump administration and into Biden?
That's a good question considering the calendar, Jonathan. But I think FCPA resolutions kind of take on their own timing and their own cadence. And I can't think of anything that the pundits have been talking about that's out there that there's going to be a rush to judgment. And as we've said just now in this little discussion about the fact that there are not a lot of monitorships being prescribed right now. So I don't see any need that in the fading light of the Trump administration that somebody's going to come push something through. But hey, we're already up on 2019. So who knows? There could be another December surprise in addition to what color hair dye Rudy's using.
Jonathan Marks, you have a question or even a comment for Jay?
Yeah, Jay, I wanted to get your thoughts with regards to even not having a monitor, but placing, I guess, or shining more light on the board and maybe having a board advisor, not necessarily required, but having a board advisor in place and, what the benefit of having somebody like that in there when you're coming out of, an issue related to an investigation like an FCPA investigation. Just your thoughts on that. That'd be great.
Yeah, I think that's a very it's a very intelligent and looking forward type comment to make. We have consistently been looking at compositions of boards, and just like there are different issues that need to be considered, whether there's ESG or diversity, I think you make a great point that if somebody on the board has experience working with ethics and compliance and corporate culture, that it would really augur and help corrective action to move forward, because one would presume that there would be board support behind what's happening. So I don't know how you officially codify that and make sure that people have to be on the boards. But I think as boards composition change going forward, it would be great to put somebody in one of those chairs that has ethics and compliance experience.
Jonathan Marks, what has been on your mind regarding the incoming Biden administration? What's
been on my mind? Well, I think you had, the Trump administration came in. I think they took their foot off the pedal a little bit in some areas, and in some areas they just seemed to kind of move along. But I do think that we're going to start to see a little bit more of a robust enforcement process at the DOJ and the SEC. What that will look like, I don't know. I mean, I think that the DOJ and the SEC have made great strides over the last, I'd say, 4 or 5 years. I can't remember if Jonathan Armstrong or Matt or Jay said this, but whoever did, good comment, providing sort of a baseline and foundational information for, the rest of us out here, in the corporate world, trying to ensure that compliance is something that is not only thought about, but thought about in a way where you can you can enhance the credibility of the company, not only from a operational perspective, but also from a financial reporting perspective. So, I do see more enforcement coming down the road in the Biden administration based on history, but I'm still waiting to see what happens.
Jonathan, do you see an increased use of data analytics, both from the regulator side, but also from people like yourself, consultants, vendors, third-party providers, and even within corporations as well to help inform compliance programs?
Yeah, Tom, that's a great question. Let me start off by talking about the SEC and what I call its new silent whistleblower program. So the SEC announced recently its first actions arising from investigations generated by the Enforcement Division's EPS initiative, or earnings per share initiative, which I think utilized what they say is risk-based data analytics to uncover potential accounting and disclosure violations caused by, among other things, earning management practices. So that's kind of interesting. I think a lot of us knew that this was coming. I think that there were some burbles about this in prior years, but it's here. And then recently they filed settled actions against 2 public companies for violations that resulted in the improper reporting of quarterly earnings that met or exceeded analyst consensus estimates. So the actions are the first arising from investigations generated by this EPS initiative, which utilizes, like I said, risk-based data analytics to uncover potential accounting and disclosure violations. So there were two that are of note, which I had mentioned. The first one is Interface Inc., which is a Georgia-based modular carpet manufacturer, and that in multiple quarters, I believe in 2015 and 2016, the company made unsupported manual accounting adjustments that were not in compliance with generally accepted accounting principles. And so that was kind of interesting. And the order finds that the adjustments boosted the company's income, making it possible for Interface to consistently report earnings to meet or exceed consensus estimates. With COVID and the fact that companies are, some of the companies that give guidance or are short-term focused, right? When I talk about ethics, short-term versus long-term, sort of that ethical thing, that conundrum that a lot of folks face. I think there's probably going to be more of that. We'll see more of this come out. But one of the things I wanted to point out is that according to that particular order, Interface's former controller and chief accounting officer, was the one that directed the unsupported adjustments, including those made to management bonus accruals and stock-based compensation accounts. So that was the one. And then the other one was against Fulton Financial Corporation. Sorry to say, that's a Pennsylvania-based financial services company, and it found that the company inaccurately presented, I think, its financial performance in late 2016 and early 2017. And if my recollection serves me correctly, during 2 quarters in which Fulton was on track to meet or beat analyst consensus EPS estimates, the SEC's order found that Fulton's public filings included a valuation allowance for its mortgage servicing rights that was at odds with its valuation methodology described in the same filing. So there was an inconsistency there. And, and they found that Fulton, I'll use the right word, belatedly reversed the valuation allowance, increasing its EPS by a penny in a quarter when it otherwise would have fallen short of the consensus estimate. So that's kind of interesting. But with regards to what we're doing and what we're seeing, from the regulators right now, the SEC in particular, we are constantly looking for, we have trend, we do trends, vertical and horizontal analysis. And now I think it's really gravitated more towards looking at other ways of pulling in the data and using that data more meaningful in order to become more business intelligent. Does it make sense? Are there red flags? Are there anomalies? The one thing that I think, the one case that I mentioned before with regards to Interface, with regarding journal entries, I think there are ways to create data analytics and artificial intelligence around that in order to kind of pull out those journal entries that could be red flags or anomalies or problematic, and things that should be either investigated internally or externally, not only by the auditors, but, certainly by, folks like us when we go in and conduct an investigation. But we have a very, very, very heavy focus on forensic technology. We use it in almost every single case. And it starts from converting unstructured data to structured data to perform analysis work, to working with our forensic scientists and our forensic analysts on building data sets that we can use to string together and piece information together in order to come to some reasonable conclusions. And then actually, test those hypotheses by matching them against what we believe to be what is the right answer. Hindsight's great, right? But matching it what we believe to be the right answer, and also confirming or validating the models that we actually built. So, we are spending a lot of time both using those types of tools and using those types of methodologies, as well as assessing the new things that are coming out on a regular and ongoing basis, which there are a lot out there. But, and some of them are good, and some of them are I think have some potential future use, but it is something that I think our clients expect. I think it's something that we expect because there's just so much data, and there's just, there's a big pressure placed on us to find answers quickly and try to contain the costs of investigations.
So, Jonathan, in terms of so much the pulling of data, but presenting it to your clients, when you sit down across from someone unlike yourself with a CPA or more of a quantitative background, you sit down across from a legally trained or lawyer CCO, is this something that they are recognizing now with the work you guys have done and the pronouncements from the Department of Justice this year, that they need to start incorporating this really on a much more go-forward basis?
Tom, that's also another great question. And one of the things that we've been working on for the past 18 months is a compliance and a compliance wireframe, or a data analytics, if you will, wireframe that ties into compliance. I think compliance officers have heard the message with regards to using data. I think the one thing that everybody's really cautious about is making sure that you have to plan this thing the right way. Otherwise, you're going to get garbage. And so I think a lot of folks are kind of, if they're trying to figure out exactly what kind of data they need in order to draw or monitor or come up with a way of looking at compliance, within the business. And that's not an easy task. Sometimes they struggle to get started. I'm hoping this wireframe that we put together and we're coming out with will kind of help facilitate those discussions and conversations and show compliance officers out there actually where to hunt, where to look, and how to actually apply some of this in sort of a crawl, walk, run, type of scenario. But I do think that from talking with the compliance officers out there, some are already, they're already doing this. I think it's one of those things if you look at it from a maturity model perspective, some are doing sort of ongoing monitoring. I think the goal here is really get to more of a continuous monitoring, whereby, these things are running in the background and that, there's some real-time input and feedback as a result of this, as the business goes forward. But, I do think it's something that that a lot of the compliance officers that I've spoken to recognize, and now I think it's time for implementing. And I think that's going to be more of an education process and sort of a trial in the beginning until you really figure out really what works and what doesn't work.
So, Mike Volkov, as our representative from the division, I wanted to ask you where you might see a Biden administration going in antitrust enforcement, recognizing that the current administration has filed one of the biggest antitrust lawsuits in recent memory involving Google. Do you see that proceeding under a Biden administration and perhaps more aggressive enforcement?
Well, I think across the board, just a few comments on the Biden administration. I think what we're going to see is a restoration of aggressive enforcement across all agencies. And for example, take OSHA and safety requirements for COVID. OSHA has no enforcement actions, has only issued, let's say, guidance that is voluntary. That's quickly going to change into mandatory requirements and enforcement actions against companies, hopefully against meatpacking, or in the recent Tyson's case, people like that will get enforcement actions. So I think we're going to see that. But I think one of the things that's going to slow down a little bit of the enforcement aggression is going to be, there's also going to be a move to restore, I think, a lot of regulations that have been cut, particularly in the environmental area and in OSHA or in safety, these types of areas. So I think there's going to be a lot of restoration getting us back to normalcy with aggressive enforcement. So there's going to be a lot of stress and strain. But no matter how people may feel about the election and the fact that we lost, the Democrats didn't win the Senate back, do not underestimate the value and power of having people who believe in government and in the good use of government in Washington, D.C. and running these agencies again. And that there's a huge amount of work that can be done, cutting from immigration to other areas where things can be sort of restored, and budget cuts and staffing cuts that were imposed on agencies. That's going to be just a huge problem to fix as well. But now, going back to antitrust and the question you asked, I think, look, we normally see over the last few years, we've seen changes, or the last few administrations, when the Republicans come in, they cut particularly civil enforcement. They maintain criminal enforcement against cartels. And I think they tend not to stop as many mergers or try to stop as many mergers. The Democrats come in and they're more aggressive in this area in terms of civil enforcement. Criminal tends to, have a life of its own and always just sort of continues. Nobody questions that, Republican or Democrat. The big area I think that's going to increase is we're going to see the FTC becoming more active, particularly in healthcare. That's one area that they like. And then they always fight with DOJ over jurisdiction over tech issues, which DOJ seem to resolve. The head of the antitrust division right now, Makem Delrahim, has done a pretty admirable job, actually, in bringing more civil enforcement cases than normally have been brought. He just happens to enjoy antitrust work and gets fascination out of antitrust work. So I think he sort of played with some of the tools in some important cases. And I don't have the pithy phrases that Jonathan has, and I'll probably ask him for one, not Jonathan Marks, but Jonathan Armstrong, because of his Brit sort of approach. But the moose on the table, or whatever it's called, Jonathan, in this time period is going to be the Google case. And the Google case is, probably it's the biggest monopolization case that has been brought since the Microsoft case in the 90s. And then just to show my age and my division experience, when the Reagan administration came in 1980, they dismissed a massive monopolization case against IBM and then proceeded to pursue the AT&T case, which had been going on, and broke up the phone company because they believed in that one but didn't believe in the IBM case. Now, whether we're going to walk into a political situation here with Google is going to be very interesting in terms of the politics, because first off, the staff was rushed to bring the case prior to the election by Attorney General Barr, probably sucking up to the president at that time, because they wanted to pick on a big tech. However, the reason that I think it's going to continue is it is a political hot potato, but I do believe that the staff, at the staff level, they firmly believed in the case. They thought something was wrong, but they wanted more time to investigate it. And there are other issues that the Democratic state attorney general wanted to bring in the case, but the only persons who did file with the U.S. Department of Justice were Republican states attorney generals. And they wanted to look at privacy implications of Google's size, as well as the Fitbit acquisition and whether or not that should have been allowed. So I think the Google case may proceed, but the question really to me is, are they going to, bring a bigger case? Are they going to try to amend the case? Because I think the staff wanted more time to investigate. They wanted more time to look at these other allegations, and they also wanted to build a better case. And there's so much work that's involved in this case. It's a massive case, as anybody could imagine. So we're going to see a return, in terms of aggressive antitrust enforcement in the civil area. The criminal area, they have a massive ongoing investigation of the generic pharmaceutical industry, which is just big, and they're going after the chicken processing companies that were engaged in a long-standing cartel to raise prices for chicken. And those cases are going to continue on as well, those types of criminal cases. But hold on to your hats. It's going to be a more interesting time. I actually happen to know several of the people who are working on the review of DOJ, and who's going to be the attorney general is going to be an interesting issue, to say the least. I don't think Sally Yates is going to come back. That's too difficult of a confirmation hearing or too incendiary. But you're going to see somebody good come back. And I have a friend, I think, who's going to try to become the deputy attorney general. So, that way we can everybody on everything compliance will probably have immunity, and we can go back to our, usual misconduct, which will be good. So, I mean, we'll have a friend in the department, which is what we need. And hopefully we won't get picked up like Rudy Giuliani does when we go in there to talk to them.
Jonathan Armstrong, do you have a question for Mike?
Yeah, I do. Yeah. I think certainly the European Commission's agenda involves antitrust actions against big tech as well. And obviously, Google, Microsoft, Facebook have previously been on their radar. And I think things like the Fitbit deal might well be there as well. And my sense is that there are many at the Commission who've previously wanted to do stuff jointly with the US. And certainly in the last 5 years or so, that's trailed off as well, as I indicated earlier, because of these wider trade conflicts between the EU and the US. So do you think a new Biden administration is going to sort of stretch a hand of friendship across the Atlantic as well and try and tag team with the European Commission on antitrust matters more?
Oh, absolutely. And I do have to say, I know however you may feel about Boris with his good haircuts, there's no doubt that Biden and him are going to get along. Biden's personality matches perfectly. I mean, he's a fun guy. Biden is a very personable individual. And I think that there are already indications that him and Boris are going to get along great. And I think that that's going to, now whether that helps or hurts Boris, I don't know. But I also think I had some cases when the EU and the US worked together very well, where there were sort of parallel prosecutions. And I think we're going right back to that. I think if anything, the EU Antitrust Commission has had a great relationship with the U.S. antitrust enforcement people. And I will be glad to see that restored because I think they do great work in the EU. I think they, for example, they went after Google in 2018. And, they're pretty cutting edge in terms of some of their views. Sometimes they get out in front of their skis in comparison to the U.S. But on the other hand, Facebook and some of the behaviors of Facebook to me are just, calling out for some kind of enforcement actions. And I'd love to see.
Interestingly, we've just had a pure internet play with an antitrust fine this week as well. So they're called Compare the Market, a price comparison site that was enabling people to do price comparisons by having behind-the-scenes agreements with some of the vendors that featured on their site, which made them the best price because they had to have the best price only on that site. So a money-saving aim behind the site, but it ended up as the opposite because of the side deals that they'd had. So I think that'll be interesting to see how, and that was a UK domestic competition case, not an EU one. It'll be interesting to see how administrators on both sides of the pond deal with these pure internet plays and technology plays.
But there's no question, Jonathan, that the trade disagreements and the rhetoric coming from the Trump administration caused a lot of harm. I've heard that myself in terms, and not only in the antitrust area, but in anti-corruption as well. And I think that will, the relationships will be restored in a big way. And actually, David Last from the FCPA talked about that and was praised. I mean, all the work that had been done with regard to China and sharing information by DOJ under the Obama administration was quickly put on ice and screwed up once the Trump people got in. And there was a lot of potential information sharing that could have occurred with the Chinese with regard to anti-corruption activity. So, there are a lot of relationships all around the world that need to be, restored in some respect. And I think we'll see that quickly, though.
Gentlemen, we are now on to my favorite section, rants and shout-outs. I'm going to call on Matt Kelly. Do you have a rant and or shout-out for us today?
I do, Tom. I have a shout out to a man named Brad Raffensperger. For those who don't know the name, Mr. Raffensperger is the Secretary of State for the state of Georgia. You might know or might guess that Raffensperger is a Republican, and I am shouting out to him because he has stood up to enormous pressure and abuse from the Trump campaign, from President Trump, from fellow Republicans, all of whom pretty much are demanding that Raffensperger subvert the election that was held in Georgia, where Joe Biden won, and somehow decide that actually Donald Trump won, which is not true and is not the case. And I think we should all applaud Raffensperger for his, actually, first for his clarity, that he has said point blank, he does not like Joe Biden. He has said, quote, I am a Trump supporter, true and true. But he also says numbers don't lie. And the numbers are that Joe Biden won the election in Georgia. So therefore, as Secretary of State, he is going to do his job and actually certify that Joe Biden won Georgia, which he did. And it is really refreshing, frankly, which is a sad statement. But it is refreshing to see that there are still Republicans out there who value the democratic process. They do hold good governance as a paramount ethical value and commitment to the truth. That is far more than we can say for most Republican officials, and certainly for President Trump, where clearly their highest ethical priority is loyalty to President Trump. And if they can't get what they want through democratic means, then they chuck democratic means to keep what they want. That's not going to work. President Trump is still going to be removed from office somehow, some way. This is actually going to happen. But it is just good leadership and a good exemplar of commitment to process and ethical values and rules from Brad Raffensperger. So he is my shout out for this month.
Jonathan Armstrong, do you have a shout out and or rant for us?
Yeah, I have a generous shout out this time round. So about 6 or 7 years ago, I think like some of us on the call, I'm what you might call a recovering litigator. And I used to go to court every day at the start of my career. And I'd not done that for about 10 years until about 6 or 7 years ago, for reasons I won't go into. I had a bizarre day in court where I was in the press box observing a hearing, and I had to come out of the press box. The court gave me special rights of audience and make an application in a case that we weren't really a part of. And I guess for 6 or 7 years, I've had this recurring vision that could have gone really badly and the judge could have disbarred me and it could have been a complete nightmare. And so I want to shout out for Rudy Giuliani, because I think he's finally got that nightmare out of my head. I think what Rudy's shown us this week is no matter how ring rusty we are and no matter how bad our advocacy is in court, we can still tough it out. And even if our hair dye runs and even if we're charging $20,000 a day to somebody to appear in court, then things are going to be all right on the night.
Jonathan Marks, do you have a rant and or shout out?
Yeah, I'd like to give a shout out to all the scientists out there for working hard and developing vaccines for us. I think the only way to get over this nightmare that we're all living to some degree is to be vaccinated, and can't wait to get mine.
Jay Rosen, do you have a rant and or shout out for us?
I have a shout out to our better angels. And as President Lincoln spoke about this in the 1860s about trying to heal a company and bring it together, I hope going forward we can leave a lot of political rhetoric on the sidelines and start looking at those people who are our neighbors, who are waiting with us in the grocery store, and thinking that deep down we all want the same thing. We want a safe country. We want a place where our kids can go to school. So I know it's early for New Year's resolutions, but I'm looking to find my better angels, and I hope my fellow Americans can do the same.
Mike Volkov, do you have a rant and or shout out for us?
Well, I have a rant in that, and I don't mean to diminish what is occurring in the country right now with regard to the transition and the quote unquote damage to the country But I think Matt Kelly said it early on, Trump is leaving. He will be gone. And the more that the media and everybody pays attention to it, but also look at it, it absolutely has disastrous consequences, and in the end is resulting, I think, in deaths, like Biden says. But I do feel there's this sort of media just, generating lots and lots of worries and anxiety. Trump is leaving, and he will be gone, and it's horrible that we're going to have more deaths as a result of a failure to coordinate in the transition, particularly with regard to vaccine delivery, like Jonathan mentioned, and that will certainly cause great harm to this country. But the media is, and I make this comment across the board, no matter what your politics are or what silo you're exposed to. I just feel like let's put it in perspective, and Biden is coming in, and good people will be here.
I have either a bittersweet shout out or something less than a rant. And my shout out today is to Saul Turtletop. Saul Turtletop passed away in March or April of this year, and he was the father of a very good friend of all of us, Adam Turtletop. He migrated from Brooklyn to Los Angeles in the early 1960s and became an avid Los Angeles Dodgers fan. Saul Turtletop had season tickets for about 40 years to the Dodgers home games at Chavez Ravine, and he was present in the stands in 2017 and 2018 when the Dodgers lost both World Series to two teams who unfortunately were found to be cheaters. 2017, the Houston Astros, 2018, the Boston Red Sox. For those who think that cheating in sports doesn't matter, I would direct you to Saul Turtletop, who in his late 80s was hoping to see his team, the Los Angeles Dodgers, win a World Series, first time in 35 years since 1987, I believe, and was denied that privilege because of cheaters. And there should be consequences for cheaters. And there, in my mind, there were not enough consequences. So I want to shout out to the Los Angeles Dodgers for winning the 2020 World Series and clearly being the best team in baseball. So shout out to all you Dodger fans out there. Shout out to Saul Turtletop, who I hope was at the Field of Dreams. I'm sure he was watching his beloved Dodgers win this year. And a shout out to Adam Turtletop, who is just as big a Dodger fan, who, although he wasn't able to attend this year's World Series with his dad, because one, his dad had passed away, and two, the World Series was played in Arlington, Texas because of the COVID-19 crisis, he got to see his team win a World Series. So to Saul Turtletop, sorry we stole one from you. Sorry the Red Sox stole one from you, but I hope you enjoyed this one. And Adam, I know you did. So gentlemen, great episode, and I look forward to continuing the conversation. Hello, everyone. This is Tom Fox. I would like to thank you for listening to this episode of Everything Compliance. I hope you've enjoyed our exploration of what might happen under a Trump administration part 2 or a Biden administration. If you have any topics that you would like the Everything Compliance gang to explore, please leave a voicemail message on Stovepipe. It's on the Compliance Podcast Network. Also, you can shoot me an email tfox@tfoxlaw.com. Once again, thanks again for listening. We look forward to visiting with you again. We are working on a video option for Everything Compliance, so that will be an exciting option for us to put forward to you. Everything Compliance is a part of the Compliance Podcast Network and a proud member of C-Suite Radio. Thanks so much for listening.